Penny Dada, His Excellency John Dramani Mahama Chesaba yato na fie twa mu yi no ade a enwiamu bi eba ye na se anko yesede sisi konto da kwada Supreme Court mpanyim fo hwe na wo mu enyi asamna no yemfa ema no na na bra mko court no ekokoto odwa se NDC amayoko no na se mampenda Dada Mahama ene ne lawyer for epese electoral commissioner eyi nsem maku dumienu ayese misa dumienu bia no se de be ye a ho betumi hu no kra a ewo abato no sunsuanso eba ye no emu na bra woka sansam no ena owura Justin Amenuvo a ono eye lawyer ni edema electoral commission so dutu dwa chiremu se sansam a na sense misa wodo a eye mampema Mahama ne lawyer ni owura Chikata ebe kan nyina no wo de fa puna chi no de awuram enka questions o mka so bebisa no ntanya de betuma yi ekọ na wiye no Supreme Court so dutu mu se sansam misa du menu de anya de a umbeyi ano.
My lords, there are other responses in the remaining paragraphs. I only comment on the one suggestion that we are unnecessarily attempting to delay the trial. Nothing could be farther from the truth. And we actually take exception to that suggestion and that averment in the affidavit. We take strong exception, in fact, I may say, to that suggestion that we are attempting. The purpose of discovery, as I've indicated, is to limit the matters for trial. And if only she would just stick to answering those interrogatories, I think the processes of this trial would be expedited rather than to make facetious statements about our intentions. We're therefore respectfully asking that your lordships grant us leave, and I believe that upon these interrogatories being filed, they can accelerate the processes for responses from the first respondent, and therefore for the further processes of this trial. That is all.
My lords, we are opposed to this application. Lords, we rely on all the depositions in our affidavit in opposition. Lords, with respect, the answers to the questions being sought are in the petitioner's own petition, the answer filed by the first respondent and also the answer filed by the second respondent.
If I understood counsel for the petitioner, you are not under any obligation whatsoever to answer any of the questions serialized in the document annexed to the affidavit.
Yes, my lord. And it is true that no specific interrogatory has been directed to the second respondent. However, we are an interested party in this matter, and if we can assist the court on legal issues, we think we should be permitted to do so.
Yeah, Mr. Akujampa, if, as you rightly said, if it's a legal issue, if it's a question of law, we can hear you, because seriously you did not file any affidavit in regard to the facts.
Yes. That is what.
So, as a party in the petition and an interested party, if there's any legal point you want to address for the benefit of the court and all the parties, I think you can do so.
My lord, very briefly, my lord, I think the first point to make is that interrogatories must relate to matters in contention between the parties.
Subsequent statutory amendments pointed out after 2013 have provided us with new procedural regime and strict timelines. We are strictly bound to comply with CR90, and therefore we will not apply Order 22 of CR 47 of 2004 in these circumstances. We accordingly refuse to grant the application and same is accordingly dismissed.
You are grateful to the court.
I'm most grateful.